The final element that is required for forming a valid contract is legality. And basically, that just means that contracts have to have a legal purpose. Contracts with an illegal purpose or that have some sort of legality issue are treated as void. So it does not matter if there was full consent of the parties. It does not matter if both parties want the contract to be enforced. Courts will refuse to enforce any part of the contract obligation. This is an issue. One thing that I think is important to note is that legality issues can affect not only the contract as a whole. Obviously, we have the very easy examples of a contract to purchase illegal drugs, right? Even if you have a full agreement and to purchase a bag of cocaine or whatever, that's clearly not going to be a valid contract. It's going to be treated as void if there were, heaven forbid, any effort to enforce that type of a contract in court. But you can also have legality issues that affect just one particular clause in a contract. So you may have a situation where the contract as a whole is dealing with a legal purpose, right? The purpose of the broader contract is perfectly fine, but you may have one clause or a couple clauses in there that fall into legality problems for one reason or another, and we'll talk about a couple examples of those in just a second. But in those cases, you run into an issue that's called severability, and courts will have to determine whether the one illegal clause is something that is so central to the contract as a whole that basically none of the contract can be enforced. One thing that you will see very commonly, if you go and look in, if you're leasing from like a larger apartment complex, you could check in that type of a lease. If you have any kind of loan documents, trying to think what maybe possibly in some of the credit card agreements. But if you find basically any type of a contract that you can get your hands on where there's just like the pages and pages and pages of the fine print, paragraphs with all the standard terms in there. And I know we've kind of walked through a couple of those for different homework assignments. But if you dig one of those out, there's a good chance you'll find what's called a severability clause. One thing that a lot of times lawyers who are drafting these contracts will do is they'll put in a clause that basically says, look, the parties are agreeing that if any one portion of this contract is found to be illegal or unenforceable for whatever reason, that it can be severed from the rest of the agreement and the rest of the agreement should be enforced. Courts will use that kind of a clause as evidence that the contract is what we call severable, right? Meaning that the bad, illegal, not enforceable part can just be sort of cut out of the document and then we just enforce the rest of the document. Courts will use severability clauses, like they'll take it into consideration, but that's not going to 100% decide the issue. Even if you've got a severability clause, if a court nevertheless thinks, no, right, that this was whatever the problematic clause is something that really is central to the agreement as a whole. Courts are still able to and sometimes will basically say, look, there's nothing we can do with the entire contract. The whole contract is now void and it fails. So that is one kind of thing to keep in mind. And just as a heads up, right, if you ever see that language in a contract, that's kind of what it's kind of what the purpose of it is. Okay. So aside from, right, you've got the very straightforward examples like hiring a hitman, right, or trying to sell drugs that are illegal, right? And in a lot of these examples, you're clearly going to have some federal or state statute that says that, X, Y, or Z is illegal, and therefore, right, under contract law, we know that we can't have a contract based on X, Y, or Z. In addition to those kinds of issues, legality situations also come up based on what we call just general sort of public policy. This is something where you see a lot of variation in the states because these are kind of principles that are based on court decisions. They're developed in court decisions. Even in cases where you don't have a specific state statute that says this particular type of contract is illegal, courts, again, we're generally talking about appeals courts who are setting precedent for the lower courts. Courts may still find this type of contract is contrary to the public policy in our state, and therefore the courts in our state are not going to enforce this type of contract. Arbitration clauses prior to the Federal Arbitration Act were a really good example of where you saw a lot of states choosing, a lot of state courts were choosing not to enforce arbitration clauses because they do, right, give up the parties' rights to a jury trial. That's not only an important federal right, many states have even more robust, right, stronger jury trial protections than the federal constitution does. And so a lot of states said, no, like we're not going to enforce these. We think that they're kind of being, forced on generally, right, consumers. And we just, we don't think it's fair. We don't think it's right. We don't think it's consistent with our state's overall kind of public policy or legal culture, however you want to kind of consider it. And so they refuse to enforce them. You see a lot less of that now after the Federal Arbitration Act, which basically said we're setting a strong national policy in favor of the enforcement of arbitration clauses. Although you do here and there still see states kind of carving out sort of exceptions to that where they can. A lot of state courts just tend to be very hostile to arbitration, again, because of the impact on the right to a jury trial. One thing, actually, I'll just jump down here really quickly. Class action waivers and basically requirements to even go to arbitration for like big class types of claims. There have been a couple major cases in the United States Supreme Court lately dealing with the legality of these class action waivers. The Supreme Court has had to settle some issues on this in terms of the interpretation of the Federal Arbitration Act and in terms of looking at what does federal law say on this, because a lot of states, right, a lot of state courts were refusing to enforce class action waivers, especially in the arbitration context. And so that's kind of been an emerging legal issue. Where you see a lot of these public policy issues come up in general, a lot of times there will be some either, hang on one second, I have a dog to let out. Hi, Ian. Okay. So, where you see these come up quite a bit is where there's sometimes they're legal innovations, like when you saw the popularity of arbitration clauses take off, you saw a lot of these public policy decisions in response to that. You also see them with technological, just other types of innovations where the law is kind of, a little bit behind and sort of racing to try to catch up. So you may not have statutes on a particular issue yet, but you've got disputes coming up in court. One good example of that is in the early 1990s when surrogacy became not just medically possible, but it also started to get a little, still I think insanely expensive, but I think it still is. But it was getting at least to the feasibility, affordability rate where you were starting to see people seek out, right, surrogate mothers to carry a child for a couple who either could not have a child of their own or were, they didn't want to, the mother didn't want to carry the child but wanted the baby, and so they were looking for a surrogate mother. In the early 1990s, as that technology was kind of emerging and people were starting to use it, you really didn't have any state laws on this at all because it wasn't anywhere near common enough yet. But there were a series of pretty high profile cases where there was a surrogacy contract that was entered into. And then after the baby was born, the surrogate mother said, I can't give the baby up. I want to keep the baby. And so, and the parents, right, the parents who were supposed to be adopting the baby would file suit to enforce these surrogacy contracts. There were two cases, two big decisions from two state Supreme Courts. I don't remember which ones. It might have been New York and California. I don't remember. But anyways, there were two very high-profile Supreme Court cases in two different states, just within, I think, only a year or so apart from one another. And one state court decided, yes, we're going to enforce this agreement. The other state court said, nope, these contracts are contrary to the public policy of our state. We're not going to enforce surrogacy contracts. And basically, the case ended up getting referred to family law courts, just like any other custody matter would be decided, right? Where you've got different parties with different relationships to a child who may have some right to custody. The court said, no, this is a family law issue. We're going to let the family courts sort it out just like they would in any other situation. But we're not going to enforce these types of contracts and basically tell the surrogate mother who, carried the child and birthed the child, like, no, you have no rights to this child. So again, two completely opposite decisions based on these kind of public policy concerns. Now, of course, eventually, right now at this point, I mean, I haven't looked it up, but I mean, I can make an educated guess and say probably every single state by now has legislation on how surrogacy contracts are handled in that state. But early on, right, when these technologies emerge, you don't have that. And so when the courts confront a lot of times these kind of novel issues, that's a lot of times where you see these public policy differences emerge. And so you can have a lot of variation from state to state on newer types of legal issues. The final point on public policy I wanted to mention here involves non-compete clauses. Sometimes these are separate. You may have just a non-compete agreement that's just that's the entirety of the contract. Some employment contracts will have just a non-compete clause in there. This is another situation where you still see a lot of variation from state to state in terms of whether these are enforceable. Of course, these are agreements when you are employed by a company. If you sign a non-compete clause, you're basically agreeing that if you leave that company, you won't work for a competitor, right, in the same industry for a particular period of time, right, after you leave the company that you're currently with. Again, a lot of variation on these. There's been a lot of ups and downs. Just to give you kind of one example, in Georgia, the Supreme Court of Georgia, I'm going to try to get the years right. I might have to make them up a little bit. But prior to like 2000, I'm going to say 11, somewhere in there, the Supreme Court of Georgia ruled non-compete clauses are inconsistent with Georgia public policy. We're not going to enforce them. They interfere with the free market. They interfere with people's ability to go out and make a living, right? If a worker wants to leave a job and go and work for another company, we want them to have that job mobility. We're not going to enforce these clauses. Well, the business community in Georgia did not like that. And so they went to the legislature, and the legislature determined we want to cultivate a business-friendly environment, and we think the way that we should do that is by enforcing non-compete clauses. So the state legislature passed a statute that says non-compete clauses are consistent with public policy of Georgia, and they should be they must be enforced. Okay. Then, and what they said was they did set some limits on it and said that it's pretty consistent with what you see in states where they're enforceable. So it was like basically you can enforce them for up to 2 years, right? So after a person leaves their job, if they sign a non-compete clause, they can be required not to go and work elsewhere for 2 years. And then there was a certain geographic area, like a few surrounding counties or whatever, where the prohibition could take place, right? You can't, nowhere in the United States, you can't sit there and say, once you leave my company, you cannot work for a competitor for the next 20 years in the entire United States. Like, no court is going to enforce that. That's crazy. So they do have to be tailored in time and in the geographic area. But anyway, so the state the legislature of Georgia set that rule down just in the statute to provide some clarity and say this is when they're enforceable. Well, so then cases start trickling in right after the statute is passed, and there were some cases where somebody who had drafted the contract screwed up on their requirements, and so maybe said like, you know, you're agreeing not to work for a competitor for 3 years, right, or something along those lines. In those cases, what the courts did was say, oh, sorry, you screwed it up. You say 3 years, the law says 2 years, whole thing's not enforceable. We're not going to enforce the whole thing. Well, then the state legislature got upset that the court was doing that. So then the legislature amends the law to add in there, okay, here are the time limits, here are the geographic scope restrictions, and oh, by the way, if there are non-compete clauses that go beyond what's allowed, the courts are required to basically just enforce the non-compete clause up until the point that the statute allows. And so that statute was passed, I want to say, in like 2013. So you have a situation basically in Georgia where if a non-compete clause was entered into prior to 2011, it's totally void, it's not enforceable. If it was between 2011 and 2013, it is enforceable, and if you screw up and go overboard on the time and scope restrictions, it's totally void and we're going to throw it out the window. And then if it's a contract that was entered into after 2013, then it's a situation where the courts will enforce non-compete agreements up to the point where the statute allows, even if the contract language goes overboard and says 3 years instead of 2 years or whatever. So that's just one example in one state of kind of the ups and downs that we've seen and kind of the debate over kind of what public policy is and sort of the pros and cons of non-compete agreements. There are, across states, there's just as much, if not more, variation. So I always like to mention non-compete clauses in this legality context, just to make sure you certainly need to understand them, how they work, whether they're enforceable. If you're going out as a potential employee and you're reviewing employment contracts or job offers where you're being asked to sign a non-compete, it's equally important if you are the employer and you're looking for, you're considering whether to require employees to sign non-compete agreements. It's very, very important to make sure that you understand your state's law on it, that you understand the restrictions, and make sure that you come up with something that's going to be enforceable. And make sure that it's consistent with state law. If you have any doubt on it, just because of how much the variation there is, and even within a state, how often things can change. If you have any doubt, I would say this is one where it probably is worth speaking with a lawyer and getting help on researching the law and drafting a clause there, especially if that non-compete clause is very important to you. If you're going to have employees who are going to have access to client lists, if you've got any kind of proprietary like business practices, any kind of competitive advantage that you have developed that you don't think your competitors have access to, it's going to be a big deal for you if one of your employees gets a better offer and goes to work someplace else, because now you're going to be worried about, are they disclosing confidential business information to my competitor? So there are a lot of valid, legitimate reasons to use non-competes. So I would say if it's, especially if it's something that you see is very important, if you've got information to protect that your employees are going to have access to, just be very careful and really make sure that you're drafting a clause that's consistent with your state's law and that is going to get enforced by the courts. So that takes us through our final element required for valid contracts, and that will do it for today.